Hello, everyone. So this is about the terms of a contract. Um, so various statements are made about contracts in the run up to the signing thereof, and got to figure out whether this statement is a term of the contract or not. It's often an assurance. So it's not simple what a contract is, as you can see. So there are terms of any contract. Now, if you break a term of a contract, um, that will at the very least give the other side the right to seek damages, and it may allow the other party to terminate the contract altogether. So some statements made in form of the contract are not actually part of the contract. So it might be simply a representation. So if someone breaks that, or there's a misrepresentation, well, then they will have other remedies open to them. So there's misrepresentation, which is misleading somebody, either deliberately or negligently, and there are various consequences flow from that, damages that they can seek there. So and there's certain warranties which are made, and a warranty is not part of that main contract, it's part of a collateral contract. So I used to think warranty is like guarantee when I first heard that word as an adolescent, but that's not quite it. There are certain representations which are have no legal standing whatsoever, an expression of opinion. That suit looks good on you, for example. Well, a court can't adjudicate whether that's true or false. Okay, so we got major and minor undertakings as terms of the contract. So people sometimes make false representations. A misrepresentation, that's a lawyer's word for a lie. The Misrepresentation Act of 1967 is about it. Now, there's also the tort of negligent misstatement, as you didn't check what you're saying is true. And that's as per Hedley Byrne and Company Limited against Heller and Partners in 1964. That went all the way to the Court of Appeal. So misrepresentations don't have to be fraudulent in order for damages to be consequent upon them. It could just be that somebody didn't verify that the statement was true. And if the statement turns out to be false, well, then that's still a misrepresentation and actionable. So there's Esso Petroleum Company Limited against Marden in 1976, held by Lord Denning when he was Master of the Rolls. In this case, the injured party had to prove that the statement was a term of the contract and not a mere misrepresentation. But things have moved on since then. So anyway, the aggrieved party, wants to prove that a statement is a representation, and that they can take action again because of this, pursuant to the Misrepresentation Act of 1976. Anyway, but there's more. So we've got to find out what the parties intended when we're looking for what we're going to do about misrepresentations. This is absolutely key. So do the words used and the behaviour performed by the parties, would that suggest to the reasonable man that the statement was supposed to be part of the contract or not? Or was it simply a representation which was not part of the contract? Now, this is very tricky. So courts have an approximate rule about this. So these are factors they take into consideration. These are not absolute rules. And this helps them decide whether a statement is a term of the contract or not. Okay, so here are some of the factors that they would take into account. Is the person who makes a statement someone who has particular knowledge about this this area? Someone who's a car dealer, he's going to know more about cars than the average purchaser of the car. The greater the expertise of the statement maker, the more likely that it is a term of the contract. And that's as per Dick Bentley against Harold Smith Motors, 1965. Here, but in this case, the representee had greater knowledge than the representor, which suggests that this was a mere representation, not a term of the contract. There's another similar case about that called Oscar Chess Limited against Williams, 1957. Another factor that the court will take into account: the person who made the statement may have accepted responsibility for the accuracy thereof. And where he or she takes responsibility for that, this suggests that the statement was intended to be a term of the contract. And you can find that principle propounded in Shaw against Reed, 1913. But another factor which they have to consider how important that statement is. If it's vital, then it's going to be part of the contract. The less importance attached to it, the less likely it is that it is a term of the contract. As Bannerman against White in 1967. Okay, yet another factor that the bench will have to take into consideration. Was the statement followed by a suggestion that the representee seek to check whether that's true or not, right? So if the representor suggested that the representee verify its veracity, then that is probably probably a mere representation, because it's sort of casting a pall of doubt over the accuracy of the statement made. And the final factor that the judge will have to consider is if one party depended upon this term, then it's obviously more likely that it was a term of the contract. So these overlap a little bit. Okay, if I say yes, it's definitely true, and no need to check it, and the other party says, well, I'm gonna trust that, then that's more likely to induce the contract. That's as per SA Petroleum Limited against Martin 1976. So now, Lord Moulton talked about this in Halbert Simmons and Company against Buckleton 1913, that none of these factors is of itself determinative. The court will consider the totality of these factors, and the more of them which are satisfied to suggest it's a term of the contract, then the more likely it is that the judge will rule that it is indeed a term of the contract and not a mere representation. So the court will look at the evidence in the round, and on that basis they shall figure out the intention of the parties to the contract. Then there's the parole evidence rule to take into account. The parole evidence rule says that the contract is only what is written in that document, and any oral evidence is inadmissible, has no bearing on the contract. That is as per Jacobs against Batavia and General Plantations Trust Limited, 1924. Batavia as in the old name for Jakarta, Indonesia. So the objective here is so we can be sure what the contract actually is. And now certainty is something which is desirable in law, but then that tends to collide with doing justice in a particular case if we adhere to that too rigidly. Now there are times when the court will say there's an exemption to that rule. If the written document was not supposed to cover the entirety of the contract, then such a rule will be inadmissible as per Allen against Pink, 1938. The parole evidence can prove terms or a custom, and these will be implied into the said contract. Another thing to bear in mind is the parole evidence rule can be cited, and it could show that the contract is void because there is misrepresentation, there's a mistake, fraud has been committed, or we say non est factum, it is not done. Another thing to think about in relation to the parole evidence rule is that the contract hasn't yet started to operate, or indeed has ceased to operate. So that could be used to overturn the contract. And the last thing is the parole evidence rule could be used to show actually there was a separate collateral contract, which also must be taken into account. So AIB Group PLC against Martin 2001 showed yet again the objective of the parole evidence rule is to make us certain what is actually contained in the contract. So somebody wants to be sure what's actually in the contract, that he knows what he signed up to, he knows what the obligations of the other party are. So now in business contracts they often have a clause which says, and it's an entire obligation clause. That means that the written contract is the whole contract, and nothing external to that written contract is there, right? It has any legal force. So this is useful from people dredging up a statement made long ago and trying to use this as a basis for a legal action, as per Entrepreneur Pub Company against East Crown Limited 2000, or indeed AXA Sun Life Services against Campbell Martin 2011. Okay, so the objective here, as the Court of Appeal observed, is to reduce litigation so people don't sue each other, and then it reduces costs for both sides. Now, there are collateral contracts. These contain terms too, obviously. So these separate contracts will be beside the main one. if you're selling a business, you might hand over whatever your books are, your accounts, to show the soundness of the business, that is profitability. But if those books as a collateral contract are falsified or just inaccurate, then that will be breach of a term in a collateral contract. Okay, and then some of the cases already cited are relevant to this, such as Harbert Simmons and Company against Buckleton. Okay, so we have to think about implied terms. So we talked about express terms, the things that are actually said in the contract. What the subject matter of the contract is, how much it costs, sometimes when it's going to be delivered, who the parties are, things like that. The Consumer Rights Act 2015 says there's an implicit duty when a business sells a product or provides a service to a consumer, that these goods or services are satisfactory. So they don't have to be perfect, they don't have to be excellent, but they must be fit for purpose. They must be good enough. Anyway, the courts can imply other duties into a contract. So courts are hesitant about doing so, as I said, they don't want to write the contract for the parties. That's up to the parties to do themselves. If terms are usually implied into a contract, then the court is more willing to do so if this is standard business terms in that sector of the economy, or if there's a course of dealing, two parties traded with each other for decades, and there's always an unwritten rule. The courts say, well, you have to actually displace that implicit term by explicitly saying so if you're going to change your course of dealing. Right, there was Crosley against Faithful and Gould Holdings Limited, and here the Court of Appeal said that there was no implied term in an employment contract that the employer had to take into account the employee's financial well-being. So, because if they did so, they felt that would be developing the law too far. It would be unduly onerous on employers, make them less likely to hire people. So Lord Justice Dyson said that courts are not going to grapple with necessity, usually not in civil law. That's a matter for Parliament to look at. So courts often look at reasonableness, how fair something is, and there are different economic forces to take into account. That's for the parties to sort out, really. So, and Lady Hale had the same thing to say in Gaze against Société Générale in 2012. So where courts are likely to imply terms into a contract are in these situations. If there's a trade usage in that sector of the economy, it's all this way, the way between farmers, or it's always that way when you sell real property, something like that. It might be because of a certain relationship which it exists between the promisor and the promisee. It could be because they said that these unvoiced intentions of the parties, and the court has to make those effectual. It could be because statute obliges the court to do so. So let's first of all examine implicit terms in common law. So in certain areas of the economy, it's just standard practice to do such and such. And so they will say, well, there's an implied term there. It could be because of the type of relationship between the parties. Like coming back to Equitable Life Insurance Society against Hyman, 2002, Lord Hine talked about this. There are particular forms of contracts. So a landlord and tenant is an example, or the employer and the employee. There was Liverpool City Council against Irwin in 1976, went to the House of Lords, and they said there was an implicit duty incumbent upon landlords to take care of the public areas of a building, as in the stairwell, the stairs, the lift, and so forth. So the landlord in this case, which was Liverpool City Council, was looking after a building with many occupants. So there are similar terms which have been applied into employment contracts. The employer is not to work his staff so hard that they suffer ill health, as in Johnston against Bloomsbury Health Authority 1992. Employers are under an implicit contract term not to commit fraud, including against third parties, as in Malik against Bank of Credit and Commerce International SA in liquidation 1997. It was a bank that was particularly prominent in the Middle East and Pakistan, which collapsed in the mid-90s. So Malik, its former employee, said its fraudulent behaviour had damaged his reputation. Even though he hadn't done anything wrong, the fact he's associated with BCCI made him effectively unemployable in the banking sector. So another thing is another implicit term is not to renege on a promise to provide a bonus pool in Attrell against Dresdner Kleinwort Limited. So anyway, they have to act in good faith, the employer. They can't behave in a manner which really causes a breakdown of trust. So anyway, so that's it. The courts don't want to make contracts too much. It should really be for the parties. So they don't want to intrude on the parties' ability to form contracts themselves. So Scally and Southern Health Board, 1992, there was an implicit term that employers had to warn their employees about pension schemes which are going to be bad for them. Okay, or telling them that they've got to take advantage of something now before it's gone. Crossley against Faithful and Gould Holdings Limited. Here, the Court of Terms, the Court of Appeal said that there's no broad duty for employers to look after their employees' financial well-being, because what does that mean? Increasing their salary or something? No. Okay, now let's look in more depth about how the courts will act in a manner to give effect to the unsaid intentions of the parties. This comes onto the officious bystander rule. So there was a case called the Moorcock in 1889, in which was an implicit term that the use of the title dock, that the owner had to show due diligence to ensure that the river bottom was safe for the ship to settle onto once the tide had gone out. This is a business efficacy test. It's now known as the Moorcock test. Okay, so the test has changed. There was a case called Sherlock and Southern Foundries 1926, and Lord Justice Mackinnon sat on this case. And this is what he had to say in 1913. Prima facie, that which in any contract is left to be implied and not need be expressed is something so obvious that it goes without saying, so that if while the parties were making their bargain, an officious bystander were to suggest some common provision for an agreement, they would testily suppress him with a common, "Oh, of course." So that's the officious bystander rule, something which is so blatant that if somebody overhearing it said, "But don't you mean to put this into the contract as well?" that a party negotiating would likely say, "Oh, of course." We don't even need to say it. Right, there was Attorney General of Belize against Belize Telecom 2009, and this case went to the House of Lords. So here, Lord Hoffman took the opportunity to adumbrate the law here again when it comes to the implicit terms. Said this is how you have to construe these contracts. So he said there is a collection of different ways in which judges are trying to express the central idea. The proposed implied term must spell out what the contract actually means. So the term can be implied in there to make effectual the aim of the contract. That's how the man on the Clapham Omnibus will understand it. So there's a reasonableness, that's part of it. The Supreme Court confirmed this again in Marks and Spencer PLC against BNP Paribas Securities Services Trust Company in 2015. So here BNP, as in Banque Nationale de Paris, was a party receiving rent, but then Marks and Spencer's ended used a termination clause to try and end the contract and try to bring the contract to an end, even though they've been paid rent beyond when that was. So Marks and Spencer took legal action on this, saying there was an implicit term allowing them to have a refund of the rent for the unexpired period of the lease. They'd paid rent in advance, and then the lease had been ended by the other party, meaning Marks and Spencer had paid rent for a period when they were not going to get to use the building. The Supreme Court said we're not going to imply such a term into the contract. There's no reason to imply that in, even if it were reasonable to do so, although notably they didn't actually rule whether it was reasonable or not. So it's hard to work out what the repercussions of Lord Hoffman's reiteration of the right way to examine this issue is. So it seemed to go against the officious bystander rule, and that's in commercial contracts, not just in consumer contracts. So it was probable that the court's reluctance to intervene with these lengthy written contracts when a express agreement has been signed is going to change. There was Philips Electronic Grand Public SA against British Sky Broadcasting Limited 1995. He was also affirmed by Mediterranean Salvage and Towage Limited against Seamar Trading and Commerce Incorporated, The Reborn 2009. Okay, so the Supreme Court said in that BNP Paribas case that the scope of the officious bystander rule is limited, and they all showed the greatest reluctance to broaden it over much. Here's what Lloyd Neuberger had to say about it, the brother of a prominent rabbi, no less. He said, "I accept that both constructing the words that parties use in their contract and implying the terms into the contract involved determining the scope and meaning of the contract. However, Lord Hoffman's analysis in the Belize Telecom case could obscure the fact that construing words used in implying additional words are different processes governed by different rules." So that's construing words and implying words, two different things. So anyway, we could look at Yam Seng Private Limited against International Trade Corp 2013. This became before Lord Justice Leggett, and he said that terms can be implied into contracts without that much difficulty if the contract is really a skeleton, suggests you need to flesh it out. And the implication in every business contract is that someone has to carry out the contract in good faith. So therefore, and the court is loath to interfere with business contracts. They're more willing to do so in consumer contracts. The idea is that businesses are big enough to look after themselves, whereas a private individual consumer is a babe in the woods. So he must save this naif from his own folly. Okay, so we could look at other cases like Mid-Essex Hospital Services NHS Trust and Compass Group UK and Ireland Limited 2013, or Mediterranean Shipping Company SA against Cottonex Anstalt 2016. So anyway, there are lots of relational contracts. So there are also implied terms of good faith. What is an implied term of good faith? I think we might come on to that next time. Goodbye.